Good morning. Please be seated. This is the time set for oral argument in YF Bethany Inc. et al. v. 16 Bethany Station LLC, CV18-0183. Some of you may have been here for the prior one, but I'll repeat myself. Out of respect for counsel in the court, I ask that those in attendance please make sure your cell phones are off or at least on vibrate. Each side is allocated 20 minutes for argument. If there's competing or more than one counsel here representing multiple parties, let us know ahead of time how you're going to divide your time. Appellant may reserve a portion of your time for a rebuttal if you wish to do so, but you'll need to keep track of that time yourself. Counsel, we have read the briefs and conferenced this case this morning. We encourage you to keep that in mind as you present your oral argument. Proceedings are being recorded and will be posted to YouTube. So before you begin your argument, please state your name and the party you represent so that people on the internet can know who you are. With that in mind, counsel, for the appellant, you may proceed.
Good morning, Your Honors, and thank you. My name is David Shine. I represent 16th Bethany Station. The appellant in this case with me in the court this morning are my partner, Todd Atkins, and our associate, Eric Smith, who both helped with the trial and the briefing in this case. I appreciate the court's attention to this matter and understand that the court has reviewed the pleadings, and I'm sure carefully, so I will attempt to be as focused as possible on the issues that we think are relevant to a final decision on this matter. As the court is likely very well aware after reading the extensive briefing in this case, this is a commercial landlord-tenant dispute that relates primarily to the ability of the appellant landlord in this case to charge the appellee tenants, Flip Dunk and UFIT, and I'll refer to them that way throughout my discussion today, certain common area costs relative to a retail shopping center located in Phoenix, Arizona. And these costs, of course, are allocated to the tenants and charged under the specific terms of the applicable leases. The two leases in this case, that is the Flip Dunk lease and the UFIT lease, are for the most part substantially identical, and the terms of the lease, again, for the most part, are not in dispute. The court should also note that the common area maintenance provisions at issue in this case are essentially standard in the retail industry. What happened in this case and why this appellant is before the court this morning is that the trial court in this case essentially jettisoned the express terms of the leases as well as well-settled principles of contract construction in order to deny this landlord the ability to recover common area costs that are specifically called out and permitted under the two applicable leases. In doing so, the trial court improperly permitted the tenants in this case to leverage a separate zoning case that was going on at the shopping center for Z Tejas, which was a tenant that the landlord was putting in at the shopping center. Anyway, to leverage that zoning case as a pretext to avoid paying for much-needed common area maintenance and repair.
Let me pause you because you said the contracts are substantially identical, but isn't there a pretty material difference between the Flip Dunk lease and the, I can't even remember the name of it.
UFIT.
And the UFIT lease?
Absolutely, Your Honor, and I will come to that. I'm happy to address it now, and I'll come to it again later.
You're going to get to it. I just
absolutely,
you said that earlier.
Absolutely, I'm going to address it. What it relates to is the allocation and payment of capital expenses, and the Flip Dunk tenant only's position that they're not that no capital expenses are allocated to them, and that will be addressed. It's addressed in our briefs directly, and it'll be addressed in oral argument as well. Your Honors, we would submit that the record here is essentially, again, for the most part, undisputed, that all of the work that occurred on the premises, which is in dispute at this case, falls into the specific areas and definitions of common area maintenance or common areas that are set forth in both of the leases, Your Honor, and that it relates to the maintenance, repair, or perhaps most importantly, the replacement of common area improvements. And we think the record is clear that the tenants in this case and their expert both conceded those points at trial. What we suggest, though, Your Honor, is that the...
But you just threw in a word there that gives me some pause. You said common area improvements. isn't that a different concept than maintenance and repair?
Your Honor, I think I meant to use the word replacement. That was my intent. I meant replacements, Your Honor.
Okay.
It is maintenance, repair, and replacements that are specifically covered under the lease. We submit that the court made two fundamental errors in adjudicating this matter. First, the trial court impermissibly amended the leases by creating two new categories of common area expense that just simply don't exist in the leases and are not contemplated by the leases. Those terms that the court used were new capital costs and replacement costs, and I'll come back to those in greater detail in a minute. The trial court then arbitrarily determined that all of the costs that were at issue in this case fell under this new term that doesn't appear in the leases called new capital costs and were not properly chargeable or accessible to these tenants as common area costs under the lease. We submit that was fundamental error. In doing so, what the trial court did was impermissibly ignored the unambiguous language of the leases and adopted the unsupported position of the plaintiff's expert, Mr. Ponchak, and Mr. Ponchak, who testified at trial that he had never visited the center, had never actually physically examined any of the work that was done or the center's prior condition or post-work condition. He based his opinion solely off the papers that were provided to him. He had no real understanding of what the work was, where it occurred, or whether it was needed or not. And yes.
So is your position then that because it was work on a parking lot, for example, that an upgrade is going to always be something that can be capitalized?
Your Honor, what we're suggesting is that that when there is a replacement of an existing asset or existing physical structure in a shopping center, there's almost always going to be an upgrade associated with that because you're using new materials or more modern materials, and we think the court got hung up on that definition, whereas if you replace a 14-foot light post with a 16-foot light post, it's because it provides better lighting coverage. The lease doesn't preclude the landlord from recovering that cost. In fact, Your Honor, the leases, there's...
I'm not a fan of parade of horribles, but it's certainly possible, like if you decided to upgrade or the parking lot with a 7-story parking structure, that would be something that would go clearly beyond the expectation of the parties, even though you're really just upgrading the parking facilities there on the...
Absolutely, Your Honor, and that would fall under the rubric of, I think, golden bricks was the term that the appellees used in their brief. But in this particular case, Your Honor, and I'm just looking for the reference, it's in our brief, but there's a specific section of the leases. Bear with me here very quickly. There's a specific section of the leases that this would be section 11.3 of the leases, that in both leases that states replacements shall be of a quality equal to or exceeding that of the original. In addition, Your Honor, this landlord has an obligation to the appellees or the tenants in this case to maintain the shopping center as an A shopping center. That's not a static concept. Shopping centers evolve all the time, and the point or position here of the appellant is simply that the work that was done was all reasonably necessary.
Doesn't the appellee take issue with your description of an A shopping center? Isn't that kind of in dispute between the parties?
It may or it may not be. I don't know, Your Honor, I honestly don't recall whether that was an issue that was ever even raised at trial or in any of the papers. There was testimony from the experts, I believe, or at least from the defendants or the landlord's expert, that the shopping center was being maintained as an A shopping center based on his experience over multiple shopping centers.
But who gets to decide whether this is as the appellee described it, or the golden brick, or I described it, the 7-story parking structure? Who gets to make the decision? Is this solely within the discretion of the landlord that they get to decide whether it's a reasonable upgrade, or is there some role for the court or the tenants to decide what's appropriate?
Thank you, Your Honor. I think that, first of all, that's an excellent question, and the answer is, I think it circles back around to what's actually happening in this case. The plaintiffs in this case are attempting to supplant their business judgment for that of the landlord. And this isn't a 7-story parking center case or parking structure case or a Golden Bricks case. This is a case where the drainage at the shopping center was woefully inadequate, and there was flooding every time it rained. And the drainage was replaced with more modern drainage that prevented the flooding in the parking center. The west wall of the parking center was it was built as a residential wall, not a commercial wall. It was falling down and crumbling. There was uncontested testimony at trial that the wall could not be repaired. It had to be replaced, and it was replaced. But when you replace something, it has to be replaced to code. And again, the leases provide, under the rubric of common area expenses, that code replacements are part of common area expenses. In this particular case, there was testimony and evidence that the curbs and landscaping were outdated, landscaping was dying, and the landlord replaced the landscaping and reconfigured the parking lot for a more efficient traffic flow. There weren't, again, I hate to run back to 7-story shopping. Had the landlord attempted to push down the cost of a parking structure on these tenants or the cost of gold bricks on these tenants, Your Honor, I likely wouldn't be standing here today trying to convince the court that these tenants, and in particular the trial court, had simply supplanted their business judgment improperly for that of the landlord. I think the default is to the landlord to determine what is commercially appropriate or reasonable within the shopping center. And that, yes, sir.
This is a lot of, you say, I think the default is, we have a contract here that has very specific language, right? And it lists certain verbs as common area costs, right? Operating, managing, policing, insuring, repairing, and maintaining. And I accept the notion that a repair has to be done to code and there are going to be new materials involved, but a redesign of a parking lot doesn't seem to me to fall under repair or maintenance. That may be a legitimate business decision, but that seems to fall under the category of a capital expense, not a reimbursable maintenance cost. So I'm wondering what I'm missing in the express language of the contract.
Your Honor, and again, I think the evidence in this case, with all due respect, I don't think there was a redesign of the parking lot.
It was bigger, though. You expanded the parking lot.
The actual size of the parking lot, the only actual expansion of the size of the parking lot, Your Honor, occurred where they moved the west wall approximately 10 or 12 feet to, I believe, the west. I may be wrong. It may have been to the east.
Sounds like an expansion 10 to 12 feet, right?
But the testimony at trial was the wall had to be replaced, and the cost of rebuilding the wall 10 to 12 feet in the other direction created no incremental cost relative to the wall and created, I may be wrong on the numbers, but 15 or so new parking spots for the use of all tenants in the shopping center.
And there's no question that might be a wonderful thing and that the parking lot was probably better after this.
Right.
The question is whether it falls into a reimbursable expense or a capital expenditure by the landlord.
And Your Honor,
loading docks removed. I didn't see anything to suggest that those loading docks were somehow dangerous and had to be removed.
Curbs were moved, I believe.
Yeah, it may have been a great idea and an improvement, but that's not really the question before us.
Your Honor, I think again that if you take a look at the express terms of the lease in the common area cost provisions, what it states is that it complying with local, state, and federal laws relating to the common areas, repairing, replacing, maintaining the common areas, including specifically, and then it gives a list: storm drainage lines and systems, landscaping, repaving, restriping, resurfacing, and it even takes into account major parking lot repairs, painting, lighting, and similar items. And the lease contemplates and similar items. And, Your Honor, we simply suggest that to the extent any of the improvements at issue in this case don't fall within the specific items that are outlined in the lease, they certainly fall within the concept of and similar items. And again, and I'll address this later, one of the things that the trial court completely failed to do is to make, and when the trial court basically adopted the plaintiff's facts and conclusions of law on a verbatim basis, the trial court failed to make any effort to allocate, notwithstanding an expansive record before the court, the the trial court failed to make any effort to allocate or distribute these costs between what costs, for example, maybe repaving the 10 or 12 feet when they move the wall, or other things that might arguably have been incremental work that was done. Between those and things like the drainage, the wall replacement, and other things that were just absolutely necessary for the center and were contemplated by the landlord long before the Z Tejas improvements.
What's your best authority for this notion you posited earlier that we should defer to the landlord's business judgment as opposed to the tenant's business judgment in interpreting a contract?
Well, I think in this particular case, we would ask the court to simply defer to the contract and the plain language of the contract. And that all of the items, I don't think there's any dispute that the items that are at issue here all fall within the exact description and terms that are contained in the contract. I'm not sure I have any authority. I have to go back and look at our brief, Your Honor. I don't want to make any misstatement to the court. There may be some authority for the proposition that as a starting point it's the landlord's discretion, because it just makes common sense. The landlord is the party that has to look at the shopping center. Now, granted, plaintiffs or tenants provide input at shopping centers all the time. Hey, the parking lot's not looking good. The building needs to be repainted. But ultimately, it's the landlord that has to make those decisions. It has to exercise its business judgment and decide which improvements need to be made and which improvements should not be made, or which improvements should be taxable to the tenants and which improvements should not be taxable to the tenants.
The thing. If they're all taxable to the tenants, you have a lot of improvements being made all the time. Right?
Well, I think landlords...
This isn't just a question of what should be done and what shouldn't be done. This is a question of what the landlord has to pay for, the tenant has to pay for.
Your Honor, you're absolutely correct, and I think we're in agreement on that point. The argument is, or the appellant's position is, that in this particular case, the trial court didn't properly interpret the lease, didn't properly look at the actual work that was done, basically rewrote the lease to create a new category of common area expenses that aren't even identified in the lease, and then decided that 100% of the improvements in this case, when clearly many of them didn't relate to the Z Tejas thing and were absolutely needed at the shopping center, fell into this new category.
You said many of them. Do you concede that there were some of them that weren't properly, shouldn't have been assessed to the lease?
Your Honor, for the purpose of oral argument today, I would agree that there were a portion of them that some argument could be made that they fell outside the scope, but I think the stronger argument is the obvious one is moving that wall, the west wall, 10 feet, because there was undisputed testimony at trial that the cost of moving the wall 10 feet was, the incremental cost was zero. The wall had to be rebuilt. There were some paving costs that were associated with paving that open area that was created. Your Honor, perhaps those paving costs were in addition to, or they created new parking.
What about all the as I read the record, there was quite a lot of, I think, moving of the islands, rejiggering in order to make more spaces in this thing. And that doesn't strike you as something that's more of an upgrade than a repair?
Your Honor, I think as outlined in appellant's briefs, that the actual incremental parking spaces were largely created through restriping, which is permitted expressly under the lease.
There were expenses associated with moving islands, changing the amount of space allocated to parking versus landscaping. These loading docks that I mentioned before, I still haven't really heard about those. Those sound like, at least within the court's, within the zone in which we must defer to the court's role as the fact finder, the court could have legitimately determined that some of those were outside the scope of repair. Right?
Your Honor, assuming for the sake of discussion that proposition's correct, and I'll come back to the loading docks in a minute, what the trial court did was made no effort to segregate or allocate between permitted and unpermitted expenses. It just threw them all into the unpermitted pot and denied the entire expense amount. And as outlined in our briefing, we believe that was an abuse of discretion. It just was wrong under the implied covenant argument. Relative to the de novo review of the terms of the contract, we would suggest that all of the work that was done expressly as provided in the contract. I see I'm down to 2 minutes. I'd like to reserve 2 minutes for rebuttal, if I may.
I'll give you some extra time because I want you to talk about what I asked you earlier, the special provision, for lack of a better phrase, on the flip dunk lease. Why isn't that make them a whole separate issue from YF?
Thank you, Your Honor. I'll be happy to address that. This again is laid out in our brief, but I will walk through it. The flip dunk lease says specifically that flip dunk shall pay capitalized expenses associated with common area improvements. What the additional provision that differs from the UFIT lease says is that the common area expenses will be amortized on a GAAP basis as opposed to the useful life basis, which would otherwise apply to
It doesn't say that. It says common area costs shall not include blah, 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 costs for capital repairs, replacements, improvements, or equipment leases which are to be capitalized under generally accepted accounting principles.
Right. So
Common area costs shall not include things that need to be capitalized.
but capitalized under, Your Honor, here's what actually happened to try.
The question whether they are capitalized under GAAP or not whether you're using a useful life or some other period.
Your Honor, correct. And here's what happened at trial. The representative from UFIT acknowledged that the UFIT tenant is required to pay the capitalized cost of capital improvements in the center, common area improvements on a GAAP basis, and the specific example.
UFIT or flip dunk?
I'm sorry, the flip dunk acknowledged that, and the specific example was the flip dunk tenant agreed to pay the capitalized expense for roofing repairs that were done, which were a capital expense to the common area.
So no good deed goes unpunished.
No
They're
good
stuck
deed
for everything.
Well, no, they're not stuck for everything, Your Honor. But what the argument that the flip dunk tenant is trying to make, we believe, is that they can cherry pick which ones they can pay and which ones they can't pay. We believe that there's two conflicting provisions in the flip dunk lease. One paragraph says you're required to pay the amortized expense. The other paragraph says you won't pay the amortized expense to the extent that they're required to be amortized under GAAP. We believe in order to read those two provisions harmoniously, what that means is that the amortization rules that apply to the flip dunk lease are GAAP amortization rules as opposed to useful life amortization rules. Any other result would mean that the UFIT tenant, or excuse me, the flip dunk tenant, my apologies, has the ability to cherry pick and decide when they're going to pay capital expenses and when they're not. Thank you.
We'll give you an extra minute and a half.
Thank you.
Okay.
Morning, Your Honors. May it please the Court. My name is Emily Ward, and along with my co-counsel, Patrick Irvin from Fenimore Craig, we represent the tenants in this matter, the appellees. The tenants are two relatively local businesses. We have Flip Dunk Sports, which is a mom-and-pop shop, if you will, that operates children's gymnastics, as well as a UFIT, which is a family-run athletic club based out of Florida. UFIT and Flip Dunk represent about 40% of the center here, and so that's why they decided to challenge these capital improvement costs. You had asked earlier about the term improvement that had been used, and that was actually landlord's term. So I'm going to refer to the costs at issue here as capital improvement costs throughout.
But doesn't that kind of assume the result?
Well, I would agree with that. I mean, we did argue that to the trial court that
We refer to them as the items because we're going to have to decide whether they're capital improvement costs or actual reimbursable maintenance costs.
Well, Your Honor, my argument is that you don't actually have to decide that. And the reason is that landlord waived the argument that we really spent a lot of our time talking about this morning. Landlord waived it by not asserting at any point in time to the trial court that this was an issue, that the leases were unambiguous. The landlord never gave the trial court any opportunity to determine that it was doing something wrong. In fact, the landlord had multiple opportunities in order to raise this issue. It could have...
Specific issue are you saying? Because I'm
Sure, the issue that the leases are unambiguous and that judgment should have been granted as a matter of law. Landlord asks that in his request for relief to this court. He asks that judgment be entered in its favor. So the landlord could have made this argument at multiple junctures. It could have done a motion for judgment on the pleadings. It could have done a motion for summary judgment. It could have moved for a directed verdict. It could have also argued this in its proposed findings of fact and conclusions of law, arguing to the court that a trial really wasn't necessary at all. But the trial did happen. It was a 5-day trial, and the trial court resolved 2 factual issues. The first was what was the party's intent in drafting the lease provisions, and 2, whether or not the disputed costs qualified as common area costs under Section 12.4 of the leases and were thus properly assessed to the tenants.
And is that latter issue exactly the issue we're here to talk about?
Well, Your Honor, I would assert we can absolutely discuss that issue because I do still believe that warrants this court affirming the judgment of the trial court. But the waiver is appropriate here. It's appropriate to discuss because at the end of the day, the trial court never had an opportunity in order to assess whether or not there wasn't an issue of fact at all. We had a 5-day trial.
Doing for 5 days. I mean, this strikes me as an extraordinarily long trial for this kind of case. What opportunity did it have for those 5 days?
To assess...
Well, you said it never had the opportunity to assess this.
Well, whether a trial was not needed at all, because the landlord never raised that argument to the court. The landlord never told the court, hey, let's not have a trial, because...
But they argued their interpretation of the contract below to the trial court during trial.
And even assuming, let's assume that the lease was unambiguous, right? Let's assume everyone knows what replacements mean or not. At the end of the day, the question still remains whether or not those disputed costs could be then assessed as replacements.
Which I think is what we're really here to discuss today. And you may not want to spend too much more time on the waiver argument.
Okay, no, that's fine. We'll move on to the definite disputed issues that were analyzed by the trial court. The first is that the landlord claims certain things were uncontested, but they were absolutely contested issues. Let me give you an example. Landlord says that, quote, all of the disputed costs related to repair, maintenance, and or replacement. That's exactly why we were there, right, is to determine what those terms meant. The landlord also said that the work benefited all of the tenants. However, there was direct evidence from Mr. Price talking about how the work absolutely did not benefit. And Ms. Strauss from UFIT testified that UFIT actually lost members. Someone had asked earlier, one of you had asked earlier whether or not one of the costs didn't benefit the tenants or was not properly attributed. And it was small, and landlord conceded this at the trial. There was a new sign for the Phoenix City Grill. And the reason is that in order to make that additional parking, they had to make the back of the center, where the loading docks used to be for the prior grocery store, they had to make that back center appealable as an area for patrons to park, right? So they had to open up the Phoenix City Grill's back entrance. And so one of the costs, it was about $2,000, was directly for Phoenix City Grill. That was assessed as a common area maintenance charge to the tenants. Landlord also says that there was uncontroverted evidence at trial that the shopping center's parking areas had numerous potholes, lacked adequate landscape and striping, and in many cases had not been resurfaced or repaved for significant periods. And I think that's really what we're here to talk about, right, is whether or not the condition of the center, that's landlord's argument, whether or not the condition of the center was such that it necessitated some type of maintenance. But the evidence at trial, specifically in paragraph 37 of the court's order of findings of fact and conclusions of law, Mr. Price testified that he had noticed changes to the parking lot conditions in months leading up to February 2011. Mr. Price even testified it looked as if there had been a brand new parking lot. It had been resurfaced, restriped. It looked very good. The trial court credited that testimony to the detriment of the landlord, and that was not clearly, there was no evidence that was clearly erroneous or that Mr. Price wasn't there. He is one of the representatives of Flip Dunk. So the trial court absolutely looked into this issue. You asked why there was 5 days. I think that was part of it, is that there were numerous construction work that had been done at the
I
case.
understand your point about the parking lot. I mean, the idea of repairing it would be to make it look like new or good, right?
Yes.
You're saying it was like spectacularly good? Or?
Well, according to the testimony at trial, Mr. Price testified that it actually looked at it as it had been recently redone. So that's exactly what I'm testifying, Your Honor. And in fact, the landlord...
That's not a common area expense?
No, but those charges that had been done, those had been done around February of 2011, and so those were before the disputed costs at issue here. And that's really what we're trying to
The
argue.
argument is that everything was just fine, and all of this work was not truly a repair, but just an accommodation to other tenants. Is that
It was a quid pro quo or a but for ZTEOS coming in as a tenant. And the City of Phoenix documents that we submitted to the trial court and the trial court accepted as bear that out. In fact, the architect who designed created the construction documents, I suppose, for the entire redesign and as well as all the other construction testified that but for ZTEOS being added as a tenant, none of this work would have been done.
As I read the contract or the agreements, and I think we need to have you kind of respond to the same issue that I asked them about earlier on the differences between the flip dunk and UFIT lease. But talking to the provisions that are in common, you have subsection A, operating, managing, policing, insuring, repairing, and maintaining the common area. Okay, so I understand your argument completely about repairing and maintaining does not mean the massive upgrade they did to the parking lot. At least that's your argument. But then there's the subsection C, which is operating.
I think that's their argument. I think the argument was that the repairs were already done.
Either the upgrade or it wasn't needed. The repair wasn't needed.
Wasn't needed.
Yeah.
I mean, it sounds like we're occupying two different universes here. These folks are arguing that what the contract means, and they're telling us that the court decided as a factual matter that these things were done for ZTEOS. Is that your position?
That is, Your Honor. I do think that the trial court made that determination. It's also our argument, actually, that the lease itself was ambiguous, and the trial court did determine what a replacement is under Section 12.4 of the leases. So that is our position, is that the trial court made that factual determination as to what the parties intended, but the trial court also made a determination as to whether or not the work fell into that category as well.
So, correct me if I'm wrong, your argument is that ensuring, repairing, and maintaining the common area does not include whatever was done to the parking lot.
Absolutely.
Okay.
Could it?
And then,
let's say that the condition was really bad before this. You have raccoons digging holes in the parking lot. So they do this nice parking lot upgrade. Mm-hmm. Could that have, in those circumstances, fit within the terms of the lease?
So you had actually asked earlier about capital expenditures, and I explored this issue at length, so I'm pretty well versed in it. If the parking lot was in actual, serious disrepair, replacing that, repaving it, et cetera, that actually would be a capital expenditure.
That wouldn't have been a repair?
It would have been a repair, and it would have also been a capital expenditure. So let me illustrate this. You had asked about the flip dunk notwithstanding language, right? So it'll all come together here. So 12.4 allows for the maintenance, the repair, and the replacement. Some of those replacements are simple things, right? Repair a doorknob or repaint some graffiti. Those would not be capital expenditures because you're not extending the useful life of that item, I suppose, right? You're just repairing something. However, some of those items in 12.4 can go beyond a repair and maintenance, and they can be capital expenditures. So your example of if there's potholes all over the parking lot, that could be a repair, but it would also extend the useful life of the parking lot. Now, in contrast, though,
so what's the consequence of that dual status for your client?
Well, it's different for each. So for UFIT, that could be if indeed it was in a state of disrepair, which obviously was disputed here, but assuming that it was, then for UFIT that could be assessed at an amortized rate over the life of whatever the useful life is of the particular item. For flip dunk, however, it could not, and the reason is that notwithstanding language that you pointed out, Judge Morse, in the beginning. I'd like to direct your attention to.
I actually was in the middle of a question, so I'll
sorry.
finish my question and then you can go on.
Sorry to digress.
So we have subsection A, which talks about just the insuring, repairing, and maintaining common area. And then there's subsection C, which actually has different language, which is operating, insuring, repairing, replacing, and maintaining utility facilities and systems including the storm's drainage lines and systems not exclusively serving the premises of any tenant or store. Why isn't, and this is where I'm hung up on the Superior Court's ruling, why isn't the upgrades to the drainage system different than the upgrades to the parking lot, and why did the Superior Court treat them all as the same?
Well, Your Honor, if I can, at the end of the day, the trial court did determine that as an issue of fact, so I can't read the trial court's mind. But if I could assess why that would happen, is that the actual drainage system itself was not in a state of disrepair. I believe Mr. Shine just told you that it was new. It was brand new, in fact. So there was no replacing. There was no
But disrepair, the language in the contract, the explicit language in the contract is different for storm drainage systems than it is for other common area costs. It says repairing or replacing. So the fact that they wanted to replace the storm drainage system, why isn't that just the end of the question here on the contract?
Sure, Your Honor. I think that would go exactly to what the parties intended by replacing. There's two different assertions of opinion here, right? The landlord asserts that replacing can be anything, right? The mere fact that we are replacing it. It doesn't necessarily have to be in a state of disrepair beforehand, whereas it's the tenant's position, which the trial court credited, that the parties intended when they negotiated this lease that replacing implies that something was wrong beforehand.
Do you dispute? He said that it was undisputed that there was flooding. Do you dispute that there was flooding when it rained?
Your Honor, I'd have to go and check the factual record before I would. I want to say that unequivocally. I'm not sure if someone testified that there wasn't in fact flooding.
Well, is there an alternate theory that this replacement occurred for some frivolous purpose, or that Z Tejas thought it would get more customers if there was a new storm retention system?
Sure. So the storm, I don't want to get hung up on that. So the storm retention system is actually at the south end of the shopping
I think
center. It's
this is
nowhere
important to
near
me,
the
so
Tejas.
don't feel like you're wasting your time arguing this.
Oh no, I would never feel that way. The storm drainage system is actually toward the south of the lot. The landlord, I do remember him testifying that it was to prevent flooding, etc. But at the end of the day, the trial court didn't credit that testimony and didn't find it either believable or
What was the alternate theory? I mean, this was just sort of a frivolous stormwater retention replacement. That's not the kind of thing that people ordinarily do for no reason. So, I mean, was there an alternate theory as to why this might have been unnecessary?
why the stormwater drainage system was unnecessary.
Might have been unnecessary.
I think that it was purely an upgrade. I don't actually think that there was anything. I think it was an upgrade of the center. I mean, there were many upgrades that were taken. Let's take, for example, the lighting, right? The landlord testifies that there was security concerns, et cetera. But at the end of the day, the lighting was just merely improved. Why? The landlord, I mean, this was the testimony that had gone out of trial that the trial court credited, was they wanted to replace that the back parking lot, and they wanted to make more parking by it used to be, behind of a grocery store. No one wants to park back there, right? Well, by installing that parking center, they wanted to improve that entire area. So I think
that goes beyond repairing and maintaining.
Exactly. That goes into improving the quality of the center in the back so that more people will park back there and not be congested up where the ZTOS is.
Stormwater.
Yeah, and which includes language for replacing. So why isn't that a different analysis? And it didn't seem like the court distinguished between the two.
The court did not distinguish between the stormwater versus the lighting, et cetera, and that's because the landlord never A, raised that as an issue, number one, and B, the actual capital improvement costs that were assessed in the, I believe, landlord reproduced that, all bundled those together. So there wasn't and the stormwater drainage cost X, and this cost Y.
Here we are on de novo review. Would you concede that there's a difference between the provision dealing with stormwater and provision dealing with general common area repairs?
Your Honor, first I would contest that we are on a de novo review. I do not believe we are on a de novo review. The standard is whether or not the trial court's judgment was clearly erroneous.
And the standard is whether clearly erroneous applies to findings of fact. Contract interpretation is a question of law.
but these are inextricably intertwined here. The court made a determination that those the parties did not intend the term replacement to include upgrades. That was that's the whole juxtaposition between Section 12.3 and Section 12.4.
Can you point me, and I'm not arguing with you, but can you point me to where the court made that specific finding?
Between
That
12.3 and 12.4?
replacing does not include upgrades?
Oh, absolutely, Your Honor. It would be paragraphs 223 to paragraphs 224.
So you're saying that's a Taylor analysis kind of determination that of an ambiguous provision?
I think that because landlord...
Clearly, if you're interpreting the contract provision, there's some aspect of a legal determination there, and it's not all factual.
I disagree, Your Honor. In fact, the entire reason that we had this trial was to resolve the tension between Section 12.3 and Section 12.4 and what the parties intended by bifurcating those sentences, by bifurcating those paragraphs.
Because it was ambiguous and you have to take evidence as to what the parties intended? Is that
Yes, Your Honor. In fact, that was the entire impetus for Mr. Ponchak's expert testimony, testifying as to industry practice.
But isn't that the bottom line of all the Taylor analysis still a contract determination that's a legal matter that's subject to de novo review?
Well, whether or not a contract is ambiguous is subject to a de novo review. However...
And ultimately the meaning of the contract also, even though there may be intermediate factual findings.
Well, determining what the parties intended is a necessarily fact-based determination. So that would be under it is our position that would be under a clearly erroneous standard, since the trial court did make findings of fact to that effect.
Well, what's ambiguous about the provision covering replacement of storm water retention systems? I don't understand. I asked before, what's the trial court doing for 5 days? I meant that. I don't see the ambiguity there or why there's anything triable. Isn't that a legally unambiguous provision? Just that one provision.
The replacement of the stormwater?
Yes.
Well, I would assert that the parties had differing opinions about what replacement means in terms of was something broken? Was something not broken? Was something just upgraded because they wanted to? Or maybe to take a step back, maybe something was legitimately broken, but the replacement that was done was not of a quality of the same caliber that would be replaced. So, for example, that I think is essentially what tenants were arguing.
That it introduces an ambiguity into the contract. It might touch on some facts concerning the work that was done. But what part of replacing storm drains or stormwater retention systems is ambiguous? That seems about as clear as you could write it.
Well, Your Honor, whether or not a replacement is truly replacing something because it's in need of repair, or you're replacing it to upgrade it, that is a different meaning of replacement. Those are two absolutely different meanings of replacement that the trial court resolved here in tenants' favor. I mean, that really is, right? Isn't that the issue? Is that on the one hand, you're replacing something because it's worn out, or are you replacing something because you want to upgrade it? And that's the tension between sections 12.3 and sections 12.4.
Well, that is a tension you've identified. It just doesn't seem to be a tension that's inherently ambiguous in the contract. I mean, you could replace something for a lot of reasons, and it's still replacement.
That is true.
If I rent a car, the contract doesn't become ambiguous because there's some question as to why I want the car.
You're right, Your Honor. However, the fact that it's not replacement is not that term is not isolated, right? It's repair, maintain, and replace. So it was, as the trial court accepted this testimony from Mr. Ponchak, he testified that when those terms are all used, some Latin phrase, expressio unis or something like that, where those terms are all used together, that implies that replacing must mean, or there is potentially some ambiguity, let's say, that replacing must mean it was in some state of disrepair before, not necessarily that you just replaced it. So the fact that replacement is in conjunction with those two other terms, repair and maintain, was really why that there was some ambiguity here, because it was landlord's position, as I believe you've kind of articulated, that a replacement could just merely be, it was there was one thing and now it's another, right? Well, not necessarily. And that's what the trial court, that's why they held a trial, to determine the party's intent. And that's why the
Ms.
trial
Ward,
court.
you need to wrap it up. I'm sorry.
Sure. And that was why the trial court made that determination in tenant's favor, was by looking at that language.
Thank you very much.
Thank you.
Thank you, Your Honors. I'll be very brief. Waiver, never any waiver. We filed motions in limine. There were plenty of evidentiary objections at trial. We presented our case to the court about what what we allege are unambiguous contract terms meant. Relative to this replacement idea, I think the court is right on point relative to the replacement of the drainage. I think the record below is clear that there was flooding in the shopping center and the drainage needed to be remediated. However, what I'd like to point the court to very quickly is the corollary to that, which I think expands the scope. If you take a look at the language of 12.4, it says specifically, common area costs shall specifically include capital expenditures for the replacement of common areas. That's not limited to the drainage issue. That's the replacement of all common areas. And in this particular case, in addition to the record below being clear that the storm drainage needed to be dealt with, there was inadequate lighting, there was problems in the parking areas.
But the Superior Court resolved all those factual disputes.
The west wall was crumbling.
Judge Morse was actually asking you a question.
Oh, I'm sorry. I missed that.
You're talking about factual findings, and the Superior Court presumably resolved those factual disputes that there wasn't insufficient lighting or there wasn't things that needed upgrade against your client.
Your Honor, but the position of the appellant is that in doing so, the trial court left the four corners of the contract inappropriately. Section 6.4A of both leases says that the common area expenses shall be paid to landlord, and this is absolute, I'm quoting, absolutely net, without any deduction of any amount of any nature whatsoever, except as otherwise expressly and specifically provided in the leases. The only two areas that are expressly and specifically provided in the leases as exception to that admonition are, one, if their improvements are to benefit a specific tenant or group of tenants, which is not an issue in this case, or it's a subsidy to a tenant, which is not an issue in this case. The simple position of
Counsel, you're out of time.
Sorry, thank you.
We'll go.
There is a theme in this case that some of these repairs were an accommodation to an incoming tenant.
Your Honor, and I'll answer this very quickly. An accommodation to an incoming tenant is not an express exclusion under the lease.
No,
it
but
may.
A subsidy is. And I was being euphemistic when I said accommodation.
Okay, but Your Honor, both of the tenants in this case agreed at trial in their testimony that there was no subsidy to Z Tejas. The subsidy is not an issue in this case. They agreed to that. That's part of the record below. Thank you.
Thank you for your briefs and presentations. We will take the matter under advisement and issue a written decision in due course. We will now be at recess.